Hello, everyone, and thank you for joining us today. Today, we're here to present Module A, which covers laws and regulations and basic introduction to affirmative action. Now, as a disclaimer, the information in this PowerPoint is provided for general information purposes only, and these materials are not intended to provide legal advice. These copyrighted materials may not be reproduced, copied, or used without prior permission from DCI Consulting. Today, we're going to cover topics generally summarizing equal employment opportunities and affirmative action. We'll get into the different agencies that enforce them, looking at how the OFCCP is structured and how it was created, then determining what is affirmative action, followed by the thresholds that signify a government contractor, then taking a deeper dive into those OFCCP regulations. Finally, finishing off on some self-ID guidance. Now we're going to go into the different enforcement agencies. Below are the Equal Employment Opportunity Agencies. The most left logo on the bottom is for the Equal Employment Opportunity Commission, or EEOC. On the right is the emblem for the Office of Federal Contract Compliance Programs, or OFCCP. Both are responsible for making sure that non-discrimination and equal employment opportunities are provided for all employees in employment-related decisions. This includes things like training opportunities, work assignments, company-sponsored social events, and other selection procedures. The OFCCP is delineated in blue and is responsible for enforcing the three regulations below: Executive Order 11246, VEVRA, and Section 503. All three regulations apply to federal contractors and subcontractors. Now, the EEOC, which is delineated in green, is responsible for enforcing Title VII, ADAA, and ADEA. These regulations apply to all public and private employers. Below is the general timeline of federal EEO laws ranging back from the 1960s to the early 2000s. Within this timeline, we can see when all 6 regulations were passed, covered under OFCCP and EEOC. These include the Civil Rights Act, Executive Order 11246, Americans with Disabilities Act, and Title VII of the Civil Rights Act. EEOC as a whole is a more reactive body, which takes action when there is a complaint submitted to the organization. The EEOC will then collect back pay as well as compensatory and punitive damages under Title VII. OFCCP, on the other hand, selects federal contractors and subcontractors to audit using an administratively neutral selection process. The OFCCP can also conduct audits if a complaint is submitted to the agency. Unlike EEOC, the OFCCP will only collect back pay of findings of alleged discrimination. We will now go into the history of OFCCP and the structure of the agency. The OFCCP, or Office of Federal Contract and Compliance Programs, is an agency within the Department of Labor. As stated before, this agency enforces equal employment opportunities and affirmative action regulations. These regulations include Executive Order 11246, Section 503 of the Rehabilitation Act of 1973, and the Vietnam-era Veteran Readjustment Assistance Act of 1974. The OFCCP will conduct periodic compliance evaluations on contractors covering all three regulations. Looking at some of the landmark dates, in 1961, President John F. Kennedy issued Executive Order 10925, which instructed federal contractors to take affirmative action. Later, in 1964, the Civil Rights Act that prohibited employment discrimination for all employers over 15 employees was passed. Then, in 1965, President Lyndon Baines Johnson issued Executive Order 11246, which required all government contractors and subcontractors to take affirmative action. Executive Order 11246 was then later amended in 1967 to include women. It also required contractors to make good faith efforts to those underutilized groups. Continuing on those landmark dates, in 1973, the Rehabilitation Act was passed, which required contractors to take affirmative action and prohibit discrimination on the basis of disability. Then, in 1974, VEVRA was signed, requiring federal contractors and subcontractors to provide equal employment opportunities and take affirmative action to all protected veterans. Lastly, in 1974, President Jimmy Carter issued Executive Order 12086, which provided the transfer of contract compliance functions relative to affirmative action and equal employment opportunities under one office. This essentially created the Office of Federal Contract Compliance Programs. The ILG, or Industry Liaison Group, was then created in the 90s to help open up communication between the agency and the contractor community. ILG holds annual conferences, conducts periodic meetings with OFCCP regions, and it increases transparency with the community. ILG has also expanded to include other government agencies such as EEOC. Looking at the OFCCP's national structure, we see that the office of the director as the highest level, which is also a politically appointed position. Underneath the director's role is the Office of Enforcement Directors, the Division of Program Operations, the Division of Policy and Program Development, and the Division of Management and Administrative Programs. Reporting to the director of OFCCP is also the 6 nationwide regions and their regional directors. On this slide, we see the structure of the 6 regional offices. With the regional director as the head, each office has multiple district directors. Each district director then has assistant directors with several compliance officers reporting to each assistant director. Most audits will be conducted by these compliance officer role. This slide shows us the map of the 6 OFCCP regions. We see the Northeast region, the Mid-Atlantic, the Southeast, the Midwest, the Southwest and Rocky Mountain region, or SWARM, and finally, the Pacific region. Each region has a similar structure as displayed on the prior slide, with one regional head, all reporting to the federal office in Washington, D.C. Now we'll look at what is affirmative action and what does equal employment opportunities mean. Affirmative action means that employers are required to take actions to ensure that all individuals based on any protected class have an equal opportunity for employment and towards all employment decisions. Overall, the central premise of affirmative action is that over time, an employer's workforce should generally reflect the sex and racial breakdown of the qualified workforce that the employer is recruiting from. For example, if an employer is recruiting from a particular region, like the Washington, D.C. metro area, over time, the employer's workforce should represent the qualified workforce in that particular region. Part of affirmative action, there is also proactive steps contractors need to take. Action-oriented programs must be designed by contractors to ensure that equal opportunities for qualified women, minorities, individuals with disabilities, and veterans are taken. These are designed to promote equal employment opportunities, eliminate discrimination, create opportunities to make a difference, remove all barriers in the workforce, and level the playing field at every step of the employment process. No matter what, affirmative action is not preferential treatment for any particular group. There are not any quotas or set-asides. They aren't intended to develop a system to promote or hire unqualified individuals, and it is not about requiring different criteria for selecting certain protected groups. To create equal employment opportunities throughout the workforce, 3 different steps can be taken. Good faith efforts and outreach need to be provided for women and minorities, veterans, and individuals with disabilities. Employers are also required to monitor all hiring and promotion practices to ensure that there aren't any biases on any particular group. Lastly, employers are required to train managers, recruiters, and other HR staff on affirmative action obligations, as well as interview and selection procedures. We'll now pivot to figure out whether an organization is a contractor or subcontractor. A prime or primary contractor is defined as directly entering into a non-exempt contract with the federal government. This may be from a purchase, sale, or use of supplies and services. A subcontractor, on the other hand, enters into an agreement with the primary contractor for the purchase, sale, or use of supplies and services to participate towards the performance of the original federal contract. This then covers them under general contractor obligation and requires them to follow similar regulations as the primary contractor. There are two types of contracts that an employer can support for the federal government. Contracts are either considered a construction contract or supply and service contract. Supply and service contracts include the use of real estate properties, utilities, transportation, research, insurance, fund depositories, and lastly, goods and services. Most contracts with the federal government are considered under the supply and services. The two types of construction contracts are either direct federal construction or federally assisted construction contracts. Both types of contracts with the federal government come with different monetary and employee thresholds for when the contractor is required to follow each of the three regulations. On this slide, we see the threshold and employee counts for Executive Order 11246. As you can see, there are differences for supply and service contracts compared to construction contracts. For both construction, supply, and service, there are differences between basic coverage and AAP coverage or the 16 specifications for construction. Seen in this slide, the threshold and employee counts change in regard to each regulation. We see for Section 503 that basic and AAP coverage, monetary, and employee count thresholds are different compared to Executive Order 11246. On this slide, referring to VEVRA thresholds, we see the monetary thresholds are significantly larger compared to Executive Order 11246 in Section 503, each being $150,000 or more, while the employee counts are similar to Executive Order 11246 and Section 503. We can see when bringing in all information for Executive Order 11246, Section 503, and VEVRA, construction also has different employee counts and financial thresholds. This view shows how each one changes as we look at each regulation. For supply and service contracts, there are contractor obligations for statistical analyses as well as written narratives. All analyses and narrative criteria are listed below, but they will be further explained in the following modules. We're now going to take a deeper dive into OFCCP regulations that contractors are responsible to follow. As stated before, the OFCCP is responsible in covering the following regulations. For Executive Order 11246, contractors are responsible in establishing goals for women and minorities that are underutilized within the workforce. The regulation also outlaws discriminatory practices based on sex, race, religion, sexual orientation, and gender identity. The second regulation is Section 503 of the Rehabilitation Act. Under this regulation, individuals with disabilities are covered and requires contractors to establish utilization goals of 7% per each job group in each affirmative action plan. Contractors are also responsible for evaluating proactive efforts and conduct outreach towards these groups no matter if the contractor hits that 7% utilization goal or not. Lastly, contractors are also responsible in following the Vietnam-era Veteran Readjustment Assistance Act, which covers all protected veterans. Within this regulation, contractors are responsible in establishing a hiring benchmark for the affirmative action location as a whole. The benchmark changes every year based on the current employment status. Similar to Section 503, under VEVRA, contractors are responsible to evaluate proactive efforts towards protected veterans. The following few slides go into details on each regulation and the particular requirements covered underneath each one. With Executive Order 11246, we see that AAPs need to be developed for each location with 50 or more employees. There is then a written narrative, which was mentioned before, with several pieces designating responsibility, duties, and action items throughout the organization. The third line down, we see the establishment of placement goals for women and minorities, where we see underutilization compared to what we'd expect to see within the workforce. This topic will be further discussed in later modules. There's also requirements for the contractor to run analyses within all aspects of their selection procedures. This is to see if any group are being disproportionately affected compared to others. Lastly, all results found in completing the affirmative action need to be communicated throughout all levels of management to help in improving the organization and decreasing all barriers in the workforce. Since its creation in 1965, there have been amendments starting in the early 2000s to Executive Order 11246. As seen, these amendments include equal protections of the law for faith-based and community organizations, an amendment on paid transparency, and an amendment prohibiting discrimination based on sexual orientation and gender identity. For Section 503, there are multiple requirements covered underneath this regulation. The first is developing an affirmative action plan describing policies, review of personnel processes, reviewing mental and physical qualifications, as well as conducting data collection. There is also the requirement for applicants and employees to self-ID using the OMB approved form for disabilities. There is also a utilization goal of 7%, which needs to be applied for each job group within each affirmative action plan. One of the most important parts of Section 503 is the assessment of outreach and recruitment efforts. There is also the requirement of posting and notices. Contractors are responsible for incorporating the EEO clause in the subcontracts and adding the EEO tagline to all job postings and listings. There is also the specific requirement of reasonable accommodation for any employees who request one. Lastly, it is required that all personnel need to be trained that are involved with recruitment, screening, promotion, and disciplinary, and any other related procedures to ensure that the commitment to affirmative action is implemented. Pivoting to VEVRA, this regulation covers all protected veterans. Individuals classified as a protected veteran are as followed: a disabled veteran, an active duty wartime campaign badge veteran, a recently separated veteran, and an Armed Forces Service Medal veteran. VEVRA is designed to employ and advance all protected veterans and to ensure that there is no discriminatory actions against protected veterans. Under VEVRA, a veteran hiring benchmark is established for contractors to compare all hires against this hiring benchmark for each affirmative action plan. The hiring benchmark is provided to contractors annually from the Department of Labor, or can be developed by the contractor itself using components within the regulations to establish that number. Posting and notices need to be maintained with all job openings with the appropriate ESDS. Similar to Section 503, VEVRA also requires contractors to post an EEO clause for subcontracts and for all job postings. There is also the mandatory assessment and evaluation of all outreach and recruitment efforts to see if your outreach efforts are positive towards the veteran community. The last part under VEVRA requires VEVRA affirmative action plans to be available for all applicants and employees if asked by an individual. All metrics may be withheld, but the rest of the VEVRA affirmative action plan may be requested. This slide further goes into details of different delineations of a protected veteran. The categories of a protected veteran are as follows: a disabled veteran, a recently separated veteran, an active duty wartime or campaign badge veteran, and lastly, an Armed Forces Service Medal veteran. If any individual identifies as one of these four categories, they are considered a protected veteran and protected under the VEVRA regulations. We will now slightly review some of the self-ID guidance covered underneath these regulations. Contractors are responsible in soliciting race, ethnicity, and sex from all individuals who meet the definition of an internet applicant. The explanation of an internet applicant will be further explained in later modules. When it comes to applicants, contractors can make self-identifications part of the registration processes if job seekers post their resumes on a database. There are some caveats to this. First off, all self-IDs must be voluntary. An applicant may choose to not self-ID at all. Second, any failure to self-ID would not prevent a job seeker from posting their resumes towards the desired posting. Third, all self-ID data should be electronically stored separately from the resume information, which will be reviewed during the selection procedures. This would prevent anyone reviewing the application to know the job seeker's race and sex information. Lastly, this slide explains the differences between individual with disability self-identifications and protected veteran self-identifications. For both regulations, Section 503 and VEVRA, contractors are responsible to conduct pre- and post-offer invitations to self-ID. For Section 503, there is also a mandate for contractors to invite employees and incumbents to self-ID. Additionally, for Section 503, there is a prescribed form mandated by OFCCP which is required to be used for all self-identification procedures. For VEVRA, there is also recommended language but no prescribed form like Section 503. When providing responses of self-ID, Section 503 and VEVA are similar, with each one providing a yes, no, and I do not wish to answer option. Though for Section 503, there is also the ability to skip the form as a whole, which is also seen as a viable option. Further discussion on self-IDs will be brought up in later modules. Thank you very much for joining us today. That concludes Module A on laws, regulations, and basic introduction to affirmative action. Please feel free to join us in our next module on affirmative action and non-statistical compliance obligations. Thank you for participating. If you have any questions, please feel free to submit them to your DCI consultant or directly to info@dciconsult.com.